Members, we will now proceed with the Data Protection Bill 2023, Bill number 14 of 2023, published on the 20th of July 2023. The Honorable Member, Attorney General and Minister of Legal Affairs, Mohabir Anil Nandlall. And just to let members know that breakfast has been ordered and should be here by 7:30.
Mr. Speaker,
Honorable members from the gallery, you're not allowed to come into the assembly.
I rise to begin the second reading of the Data Protection Bill, which is before us this morning. Mr. Speaker, this is a bill that is long overdue, as we have been for several years now moving at the level of the government as well as in the private sector towards digitization. And I dare say, Mr. Speaker, in our individual and personal lives, we have been moving in this direction as well. Mr. Speaker, all of us have access to the internet, and at the level of the government, we have launched e-governance initiatives on various platforms. We have a digital identity card, which we will debate later this morning. We are offering ICT hubs across our interior regions. Soon we will be bringing a telemedicine bill. The Ministry of Health has already begun to accumulate our medical records and storing it in a digital information system. We have passed recently the Electronic Communications and Transactions Bill. So, Mr. Speaker, Guyana is well on its way into traversing the digital age, and this bill, therefore, is of utmost importance as it seeks to establish a framework to support the accumulation, storage, use, dissemination, etc. of data. But most importantly, Mr. Speaker, it sets out a protective framework through which the data collected and used on our behalf, and when I say our, I mean the collective, the people of Guyana, that data is protected. Mr. Speaker, a person's data invariably consists of very personal, inalienable, biometric and biographic information peculiar to that person. And a person is entitled to the privacy of that information in the same way that we have a right to freedom of expression, we have a right to liberty, we have a right to property, we have a right to privacy. Unfortunately, the current construct of our laws do not safeguard this very important right. And this bill, for the first time, Mr. Speaker, seeks to set a statutory framework for the protection of data that we are using and we are accumulating every day in our lives. Mr. Speaker, the Universal Declaration of Human Rights recognizes the right to privacy as one of the fundamental rights guaranteed. to the citizens of our country. And the various international conventions to which we are a signatory as a country also enshrine the right to privacy. Our Constitution, Article 154, which speaks to fundamental rights, bind the state of Guyana to observe these international covenants as part of our constitutional architecture. And that architecture, of course, it will now include those convention rights, as well as we are now welcoming it in our country as part of our statutory landscape. Mr. Speaker, in crafting this bill, we have used the well-tested European model which exists in all the European member states, and it is titled the General Data Protection Regulations and approved by the European Parliament. That model has now become the gold standard for data protection laws, and many countries in the Caribbean, including Jamaica, Barbados, Belize, St. Lucia, and Grenada, have enacted legislation already based upon this European model. In drafting this bill, Mr. Speaker, we took guidance from the United Kingdom, Jamaica, Barbados, Mauritius, and Kenya. So we did not invent the wheel, Mr. Speaker, but we simply followed legislation that have been enacted across the Commonwealth and the Caribbean. Mr. Speaker, in terms of consultation, this bill has received widespread consultation. The bill was published online in April, and we invited comments from members of the public. Unfortunately, we only received 2 sets of comments. We examined those comments, and where necessary, we incorporated them in the bill. We received technical support, Mr. Speaker, from data protection experts attached to Mount Sinai Hospital as part of this architecture. Will it embrace our ability to accumulate, collect, store, and use medical information as part of our data bank? Mr. Speaker, the Law Reform Commission of Guyana did a comprehensive review and a comparative analysis of the bill with other Caribbean data protection laws and had no objection to the bill. In fact, they said, and I quote, "The draft bill represents an updated legislative model for data protection. The provisions of the draft bill build on existing regional legislative models." Mr. Bartlett Morgan, a lawyer from Barbados, whose work in the area of data protection and privacy are well known, commented on the bill, and if I may be permitted, sir, to borrow what he said this: "Guyana's new data protection bill is impressive. It is probably the most advanced and, at the same time, fit-for-purpose privacy law that I have seen emerging from the Caribbean region to date. While there is some room for fair criticism, there is a lot to be pleased about in the direction of the draft law. The drafters have clearly assessed prior efforts of other countries in the region and further afield and sought to strike a fair balance between competing interests of data subjects and data controllers." So, Mr. Speaker, our bill has been endorsed both by a foreign expert and by our local Law Reform Commission. Mr. Speaker, if I may go quickly through the main elements of the bill. The bill has a commencement clause, and this is important. The minister is empowered to assign different days for different provisions of the Act to come into operation. This is critical as we understand the need for an implementation plan for the bill. The bill contains provisions which imposes obligations on all persons and entities who process data. This means that these persons and entities must be aware of their obligations given time to put their house in order before we can enforce the law. And we are not unique in this regard. For example, in Jamaica, the Data Protection Act was passed in 2020, but will come into force this year. Of course, we are hoping not to be so protracted in our bringing the bill into force. The bill has territorial reach and will apply, however, to agencies in Guyana as well as outside Guyana once there is a sufficient connection with Guyana, and that connection is set out in clause 3 of the bill, which I don't think I need to recite at this hour. The data controller, Mr. Speaker, is a natural person or legal authority, public authority or agency or other body who determine the purpose and means of the personal data. And of course, Mr. Speaker, it goes on to set out the infrastructure now that will run this data machinery. The data protection principles are also set out in part 2 of the bill, and these are the safeguards that will govern the collection of data, the use of data, where the data will be stored, for what purpose data will be collected, and the limitations that one would have, and they are all set out in the Act. Mr. Speaker, the Act also details in a comprehensive way the process that will be employed in the accumulation of data, and it highlights concepts such as lawfulness of the exercise, so you can only collect a person's data for a lawful reason. The process that you use to do so must be fair and must be transparent. And the bill sets out all the mechanisms that will ensure lawfulness, fairness, and transparency. Mr. Speaker, as expected, an important component of the bill is the consent of the data subject. Naturally, consent would be an imperative ingredient of any undertaking that involves the personal information of subjects in a free society. So a large part of the bill details how consent is to be obtained from the data subject. And this consent also will be granted only when the data subject is satisfied that the data will be used for a lawful process, will be obtained transparently and fairly, and will be adequately safeguarded once taken or collected. And of course, they must be satisfied that it is going to be used for a legitimate reason or for legitimate purposes. Mr. Speaker, of course, there are instances where consent will not be required, and these are laid out in the Act as well very carefully. in this in the same way that the Constitution limits the freedom of the fundamental rights and freedoms that we all enjoy as citizens, because they are not absolute rights. In the same way, the bill limits the right of the data subject to restrain use of the data or to refuse to participate in the data collection process. So those exceptions are also set out in the bill, and once those exceptions are satisfied, then your consent really doesn't matter. And those are very clearly defined and set out. There is also, of course, a right of correction of data, a right of erasure if the data collected is no longer valid, or there is a change of data, or there is an error committed, or because of a change the data collected is now inaccurate. All of those things, the bill allows for a rectification of that register. The bill also speaks to a right to data portability. So once the data is in one platform, it can be used or transferred to other platforms. Of course, based upon the mechanisms and procedures set out in the Act, and there is always at every stage a right to object, and there are certain categories of data or certain circumstances when the data is required when one will not have that right to object. Mr. Speaker, the bill also provides, as all bills of this type do, it makes allowance for cross-border data transfer, and it sets out the circumstances where that is being done. And that is done right now. We have cross-border sharing of data for a very long time now. So I know when I say these things, it can excite all kinds of misgivings in the minds of people. But these things happen already. We are simply putting a framework now in place that will protect it from being abused and will streamline it in a regulatory framework to which all can refer. So there is certainty and it now has legitimacy. There are, as I said earlier, there's a category of exemptions that are set out in the bill, and there are, sir, a series of offenses created by the bill if there is misuse, abuse of data collected, or one gives wrong data knowingly or falsifies data in the exercise. Mr. Speaker, as I said, there is an elaborate structure established in the bill, which is headed by a commissioner, and then below the commissioner you have data processor and data protection officers. These are all persons who are going to be appointed by this data commissioner, and they will manage the machinery across the country. The data commissioner has powers to review the work of the data processor and those under him. They have to answer to him administratively, and he has certain powers over them. Most importantly, Mr. Speaker, this is an office holder who is appointed by the President, and he can only be removed upon grounds set out in the law, in the bill, and they are akin to grounds upon which a judge is removable from office. So there is a heavy security of tenure in the holder of this office. I say that to emphasize that this is going to be an office holder who will be performing a very impartial role and would be the guardian of data in this country, and therefore ought not to be subject to interference or undue interference with politicians, etc., as this person is an independent or quasi-independent office holder and has the requisite security of tenure. And of course, the bill provides how this system is going to be funded, etc. So, Mr. Speaker, I don't want to detain us unnecessarily here this morning, but to say that Guyana, by this bill, will now be joining a large number of countries, not only across the Caribbean, but across the globe, in putting in place a legislative framework that will allow for the legitimate accumulation, use, transferal, storage, and update of data to be used in electronic and digital transactions. We are, as I said at the commencement, transitioning into e-governance from a manual structure which has existed, and we now have to prepare every aspect of our governmental machinery as well as the private sector infrastructure to allow for this digital electronic transformation to take place as we join the rest of the world in this age of information and technology. With those few remarks, Mr. Speaker, I commend this bill to the House. I thank you.